so, my lord. I haven't done a roll call, but it looks like it.
Okay, Mr. Botha, let's hear your submissions. You say you're going to be dealing with justification, facts and law. Botha, I don't have yours. Oh, yes. Oh, I see you're going to deal with mootness, absence of record, fundamental rights, absence of justification, essential service workers.
And consultation.
And absence of consultation.
Indeed, sir, my lord. So I'm still going to deal with exactly those topics. What I've done, I've noted, obviously, your lordship's questions and interactions with my learned friends. In engaging with my learned friends, your lordship engaged with a number of topics, both directly and indirectly, that I was to address. So I won't repeat, but I will have to deal with those questions that your lordship has posed, because that was always part of what I was going to argue. I have reconstructed my argument, and I'll give your lordship my roadmap in a moment. But the consequence is that there are two consequences. I'd initially intended my argument to be briefer, and it is going to take me longer, because I've noted from some of the questions your lordship has posed that I'm going to need to take your lordship to both the facts and the authorities in more detail than I'd initially hoped. And I'm going to have to take your lordship to them in some detail. I'll endeavour to do it as briefly as possible nonetheless, but I'm going to have to work through it. I see Mr. Mokhagabe was outside. He's now back.
My lord.
I'm sorry. I would never have started if I'd known you were not in, Mr. Botha.
Yeah, I had difficulty, connecting, my lord.
I'm sorry.
Yes.
Can any of your juniors or others, if they know somebody is out or somebody's, can they please put their hand up? Because otherwise we'll be making an assumption.
Yes.
Boitumelo, can you please keep a note of who is, if someone is not in? Because we shouldn't have that situation where we have submissions taken in the absence of a party, especially of lead counsel. All we got is Mr. Botha just spelling out his roadmap.
Yes, yes.
He hasn't started with his submissions at all. He said he might have to repeat now and again, but he'll try to avoid it. That's about what he said. And he's still sticking to the roadmap that was set out in the document they gave us yesterday morning.
Yes.
Okay, so
what my lord, if I may be allowed to, to address the court, is that it seems there's a pattern which has evolved. When the council are addressing the court, because they seem to veer outside. The topics which they have delineated as to which party is going to argue. And secondly, I thought there was an agreement yesterday that there won't be a repeat or overlap, by the parties regarding these arguments.
No, there won't be. I'm going to deal with it as, and if I may answer through your lordship, my learned friend. A lot of the engagement, as I was explaining, and my learned friend was absent, and I apologize. I didn't know he was absent. I saw his team. I assumed he was there too. My apologies, my lord. But what is very clear, my lord, is that a lot of the questions your lordship asked, of course, engaged topics that I was going to deal with, and I still need to deal with those, and I'm going to stick to the topics I'm going to deal with. But the consequences I was explaining to your lordship is I may be a little bit longer, and I'm going to have to just deal with it in somewhat more depth. And there's another reason, my lord, why, with respect, I'm going to ask your lordship's brief indulgence. I'm going to exceed. Oh, your lordship's left.
Okay, I'll call Judge.
Thank you.
Am I back?
Your lordship is back.
I'm not sure whether Senior Counsel Mokgakabe has logged off as well, or is he still here? Oh, he's here. Okay, Judge.
Thank you, my lord. I was just explaining, my lord, I might be slightly longer, and I was about to request another, or give your lordship a second reason why I may have to exceed the hour initially allocated, and that is, as my learned friend Mr. Botha so aptly illustrated, with reference to religious freedom in respect of Muslims, who and we as freedom of religion represent a very broad base. Your lordship would have noted the passion and the importance of religious freedom. This judgment that your lordship is going to give is not just about the Disaster Management Act. For instance, if your lordship finds that religion is subservient to economic rights, that will have a fundamental ground-changing effect on the exercise of religious freedoms for decades to come, my lord. So, yes, there is always an appeal, but the point is that your lordship is the one who's going to determine these issues, and they are very, very important issues. And these considerations, such as where religious freedom is balanced and where it finds its place in the structure of the Constitution, cannot be overstated. And if I do not do the parties whom I represent, my lord, which are in the millions, there are millions of people which constitute the constituency of 4SA, and we're representing today. If I do not do that justice just by simply making haste, as is sometimes my want, my lord, I would be doing them a disservice. So if your lordship will indulge me. What I'm going to do, my lord, is I'm going to address a number of topics. First of all, I'm just going to deal with, this is not a state of emergency. And that picks up, it doesn't overlap, it just picks up and complements what my learned friend Mr. Botha has submitted, and in regard to the policy issue, which I will address separately. The next topic I will deal with is what I've framed, how we worship. I'm going to deal with that, and I'm going to set out for your lordship what religious rights and freedoms mean, what they mean for the constituency that I represent, those millions of people that I've told your lordship about, and what exactly they believe and where worship fits in that hierarchy. I'm then going to address, it's an element of justification, but it's certainly an element that your lordship has raised again and again, economy and religion. Now, it's something we traversed at length in our papers. There's a slight overlap on the facts with SANCF, but I'm going to illustrate to your lordship how the various submissions that Ms. Martin made actually fit together. And I'm not going to retraverse the ground that she's traversed, but I'm going to explain to your lordship, or endeavor to make submissions to your lordship, as to how these two fit together in the religious context that I represent, and why there is the issue around economy and religion is actually a red herring, and in any event is not a point that the minister was so bold to make. It's very important to remember that in these papers, your lordship has raised the issue with us. This is not an argument that the minister makes. The minister doesn't say the economy is more important than religion. She wasn't bold enough to make that statement, my lord, because with respect, it would be fundamentally flawed, as I'll seek to demonstrate to your lordship, and as with respect Mr. Botha so passionately and eloquently already demonstrated. I'm then going to deal, my lord, with the rationality examples. Why am I dealing with this? Because that is the central issue in our papers. The only evidence that there was any kind of difficulty in respect of religious gatherings is addressed in our papers. And there's three anecdotal examples. I'm going to deal with that, and I'm going to deal with the detail around this balancing between the two examples. That, of course, goes into the justification. I'm going to briefly deal with mootness. Why am I going to deal with mootness? Because your lordship had the debate yesterday about the supplementary affidavits. As part of that, I'm going to address the topic of judicial notice, and I'm going to explain to your lordship what our case is as far as judicial notice. Although the affidavits are not there, and your lordship has posed a question about a set of facts in one timeline and a set of facts in another, and whether that isn't moot on itself, I'm going to address that with reference to the government gazettes on that basis. Lord, I'm then going to deal with the polycentric approach and Section 36 and how those two fit together. In particular, I will deal with SL, which we respectfully submit is now the binding authority of the Supreme Court of Appeal, the Constitutional Court not having dealt with these regulations as yet, and in particular in that context. I'm then going to deal with two further topics, which is consultation. My Lord, there is a very clear difference between the issues raised with the consultation as regards my learned friend Ms. Martin's case and the 4SA case. And I'll demonstrate to your Lordship what those are and the case we made out in the papers. But one of the questions your Lordship posed to my learned friend was, how do you test? What is the test to decide who to consult with or not? And I'm going to give your Lordship that with reference to the Supreme Court of Appeal authorities, amongst others, in the Scalabrini case, a judgment of His Lordship Mr. Justice Nugent, which is then followed in a further Supreme Court of Appeal case. Finally, I'm going to deal with essential service workers, my Lord. That's actually a very narrow issue, very simple issue. I've taken note of your Lordship having sat on the panel that decides, or chaired that panel of essential service workers. It's a simple interpretive argument, and I'll show your Lordship with reference to Annexure D to the regulations that the Minister is not usurping any powers. What she does is she uses that essential services legislation as one of the grounds for essential service workers under Section 213 of the Labour Relations Act, which your Lordship will of course be very au fait with. But she says as listed below. And so it's a very simple point that we raise there, that on a plain interpretation she has every power. And in any event, the President gave a promise that religious workers were going to get essential service workers. He even said it in a speech. And therefore, there can be no rational basis for suggesting why they haven't been included. And then finally, I'll just briefly deal with the relief, which touches on some of the confusion yesterday in the interlocutory argument between my learned friend, Mr. Willis, and Mr. Mokgakgabe. Without further ado, my Lord, if I can start then with this is not a state of emergency. And I would refer your Lordship, because it is set out in great detail in our founding affidavit. It commences at 001-15. What we're going to endeavour to do, my Lord, is we're going to use case lines and to take your Lordship to the relevant pages.
Just a minute, I need to get your case because I have to get a different party's case.
As your Lordship pleases.
The cases haven't been put together in case lines.
No, they haven't, my Lord. They are consolidated, but they're still separate cases. My Lord, as I understand the law on consolidation with respect to my learned friend Ms. Engelbrecht dealt with this issue. Although cases are consolidated, their facts aren't. And so the law, when you look at the law on consolidation in the Uniform Rules of Court, we still have separate papers and separate matters. So your Lordship would still do the judgment, but by convenience, what happens is you consolidate them because they have similar issues. So that's how I understand the legal position, and that's why you don't just bundle them all together as I understand it, my Lord. Has your Lordship managed to locate our case?
Not yet.
It would be under Freedom of Religion South Africa. So I don't know if your Lordship is listed alphabetically, and your Lordship's probably got thousands of cases in your case.
Especially when you sit in unopposed motion.
Yes, I know, it must be absolute chaos.
It just accumulates.
Perhaps your Lordship searches Freedom.
What is the case number?
I can give your Lordship the case number in a few seconds. It's 2619/2021.
2619.
2619/2021. Your Lordship managed to locate it?
There's another whole load. I'm going to try some other thing. I had it earlier. You see, there's another thing.
If your Lordship has your Lordship's case list and your Lordship puts in text, if your Lordship searches Freedom, it should locate the case. It does that for me if I do that.
Followed the example and it came. I'm there.
As your Lordship pleases. So, my Lord, if I can ask then Learned Junior Mr. Crompton, will just redirect your Lordship to 001-15. In fact, I've done it. So, my Lord, this is in the founding affidavit, and the point we simply make in the founding affidavit is this. This is not a state of disaster. I'm going to deal with this under another topic that Your Lordship, which I'm required to address, and that Your Lordship raised with one of my learned friends. But what the real issue here is, my Lord, under it, you've got two different forms of legislation, and this was dealt with again recently in the AfriForum case against the Minister of Tourism. That case we've also uploaded, my Lord, to case lines in the meanwhile, and I'll take Your Lordship to it in due course. But what you've got to do is the minister has chosen, or the government has chosen, a set of legislation, and they have, instead of using a state of emergency, for instance, as we explain, it is not declared a state of emergency and at paragraph 9. But what I'm going to point out to Your Lordship, and as is made very clear in the founding affidavit, is even if they had chosen a state of emergency, that does not allow them to derogate from certain fundamental rights. The point we make at 001-16, in contrast, at paragraph 10, my Lord, in contrast to the present situation where the national state of disaster is simply being extended by regulation of the minister in terms of section 27.5c. And it's been going on for months now, my Lord. It's in excess of 18 months. It's been since 13 January 2021. That could be no more effective in a state of emergency for more than 21 days from the date of declaration. So the National Assembly is supposed to extend these things. Now, the present, where you did the affidavit, was in existence for 10 months. Now, what else section 37.4 of the Constitution allows is that any legislation acted in consequence of a declaration of a state of emergency, I'm now reading at page 17, my Lord, paragraph 12, is that may derogate from the Bill of Rights only to the extent that the derogation is strictly required by the emergency, and B, the legislation is consistent with the Republic's obligations under international law applicable to states of emergency. So again, I'm going to highlight international law and foreign law in my argument, conforms to subsection 5, and is published in the National Government Gazette as soon as reasonably possible after being enacted. Further importantly, under section 37.5 of the Constitution precludes any derogation from section 37 and any derogation from the sections mentioned in column 1 of the table of non-derogable rights to the extent indicated opposite that section in column 3 of the table. The table includes section 9 in respect of equality with respect to unfair discrimination solely on the grounds of, amongst other things, religion. The table also lists other non-derogable rights that are directly implicated in the exercise of religious freedom, such as those in section 10, human dignity, and section 12, freedom and security of this person. My Lord, in that context, we submit at paragraph 14 that it cannot be that in terms of the impugned regulations, the minister can go further than she would if we declared a state of emergency. We all know the history of states of emergency in this country and how unlawful and irrational they were. Now, that's what section 37 says. It complements the argument that my learned friend Mr. Botha made when saying that with reference to Harkson and Lane, you cannot simply derogate from rights, and especially protected rights. So there's another case, my Lord, a recent case of the Constitutional Court 2014. It's Sali, S-A-L-I, versus National Commissioner of the South African Police Service, 2014 JDR 1186CC. Para 7 to 12, they conveniently summarize the law. And there it was an issue to deal with. Sorry, my Lord?
Sali was
National Commissioner of South African Police Service. His Lordship, Mr. Justice Jafta, at paragraph 7 to 12, deals with the issue that confronts your Lordship here. It says it's significant, he says, to note that the Constitution lists a number of grounds on which the state is precluded from discriminating unfairly against anyone, and those grounds include age. Notably, the Constitution does not rank discrimination on the basis of race or gender higher than discrimination on any of the other listed grounds. This means that discrimination on any of the listed grounds must be treated seriously. It is apparent from section 9.5 that discrimination based on any of the listed grounds is presumed to be unfair. The claimant need not prove unfairness. Instead, it is the person who wishes to defend the discrimination who must show that it is fair. The test for determining whether a claim based on unfair discrimination should succeed was laid down in Harkson, and my learned friend read the section. I'm not going to repeat. He then goes on, His Lordship Mr. Justice Jafta, at paragraph 10, to say, although the test was formulated with reference to a claim in which the constitutional validity of legislation was impugned with the necessary adjustment, it may be applied where the attack is directed at conduct, policy, or practice. What needs to be established at the commencement of the inquiry is whether the policy or practice on which the challenge decision was based differentiates between people. If it does, whether the differentiation bears a rational connection to a legitimate government purpose. If it does, the policy or practice may or may not, depending on the circumstances of a particular case, violate Section 9(3) of the Constitution. Where there is a rational connection between the impugned policy or practice and a legitimate government purpose, it is necessary to inquire whether the differentiation concerned amounts to discrimination. If the differentiation was based on one of the grounds listed in Section 9(3), it is presumed to constitute discrimination, which is further presumed to be unfair. This means that an applicant needs only to show that the differentiation complained of was based on a listed ground for the double presumption to be triggered. So, my Lord, at the end of the day, we submit that there is a double presumption in favor of the religious community here, which far outweighs any presumption that, or any other right, including a right to the economic interest, the pecuniary interest, as your Lordship had debated with my learned friend, Mr. Botha, and that those are actually secondary to these rights. So I'm now going to deal, my Lord, with the next topic, having framed the debate of how we worship. Your Lordship raised
in your opinion, where is the discrimination? There's a prohibition on faith-based gatherings. So why are they discriminating when you say a differentiation between people?
Yes, my Lord. So yes.
One thing we know is not a differentiation within faith-based communities, because it's in across the board, all faith-based communities.
All faith-based communities.
Right. So there's no discrimination within them. So now it's between them and who?
Anybody who's not practicing their faith. Now, your Lordship put a question, I can't remember to which colleague, but your Lordship framed it thus, to say that, but the regulations would allow you, because your Lordship seemed to suggest there was a differentiation, the regulations would allow you to go to the restaurant and to pray. Lord, with respect, the minister says, no, you can't. So what happens? I go to a restaurant, and she says this expressly under oath, and I'll deal with this under the rationality part in a moment. But she says it under oath, my Lord. So what happens is if I go to a restaurant and I pull out my Bible, all of a sudden, I'm no longer allowed to do that. That, the minister says, will break the law. Your Lordship is frozen. I don't know if your Lordship can still hear me.
I can hear you very clearly.
Thank you, my Lord.
I can hear you very, very clearly.
So, my Lord, so there is no, this is just one example, and I'm going to give your Lordship a lot of other examples under the rationality test. But here, you're distinguishing between a religious person attending a restaurant and any other citizen. Because a religious...
Once you attend a restaurant and you engage in economic activity as well as religious activity. That was my
that was your Lordship's point.
Yes.
But the minister says your Lordship's wrong. The minister says that you can't do that and it's illegal, and I'll give your Lordship the references when I get to that point. She says that would be illegal. At the moment when you suddenly start, if I get together with my family, and this is what most religious people do, we pray before we eat. And we suddenly, if we start sharing scripture around the table, and we're now gathering around those things, and let's say I gather with other friends, as long as I stay off the religious grounds, the minister says that's a perfectly legal engagement. But she says, if I start making it a religious gathering, it would be illegal. Those are her words, not mine, my lord. It's her interpretation of the very regulations she's promulgated. If that's not discrimination on the grounds of religion, I find it very difficult to find an example that is stronger than that. Now, my lord, you can also go to a number of different places. You can go and gamble. You can go to a restaurant. You can do all these things, but you cannot exercise your religion. That is clear discrimination on religious grounds, on the facts, on the minister's own version.
Give me an affidavit where she refers that to.
Lord, if you'll just bear with me. I was going to deal with that a little bit later. I'll just find the example in a moment.
Okay, then just remember to bring it to my attention.
I will bring it to your Lord's attention. It's definitely that. I'll ask somebody in my team to just find it in the meanwhile. Lord, it is in our heads as well. It's amongst, unfortunately, I've got a lengthy page of notes, but I'll definitely get there. And if not, somebody will send me the note shortly, my Lord. As regards the exercise of the religion, my Lord, what we are going to submit, my Lord, is that your Lordship said something else. Your Lordship put two propositions. And then your Lordship mentioned that you would put a third proposition, but I don't think your Lordship has put it yet. So, but the two proposition is this: isn't prayer more important? People can pray in their homes. That was the one proposition your Lordship put. And the other proposition that your Lordship put was ban is only temporary. I'm going to address those in the course of this argument, my Lord, but both of those go to exactly how people worship. Lord, if I may just give your Lordship the reference, the minister's affidavit is at 009-32 at paragraph 122. And I'll find it in our heads of argument in a moment, my Lord. It's at footnote 22 at 054-9 in our heads. Here's the context. In the founding affidavit, we said the following at para 217, which is 001-105. I think what we should do is take your Lordship there. Take your Lordship there momentarily. I'm directing, yes, to the page 105. We said at paragraph 217 that opponent says the irrationality, it's at the bottom of the page, of the regulations is also demonstrated by the fact that congregants could meet in a restaurant or conference venue and conduct their service perfectly legally, but they cannot do so legally in a religious building specifically designed for the purpose. That was our statement. The minister responded to that statement at paragraph 122, 009-32. Sure, my learned friend will take you there shortly, my Lord. But she responds, your Lordship will see a paragraph 122. Is your Lordship there?
Yes.
She says, I deny the regulations are irrational. All gatherings remain prohibited, and the holding of faith-based gatherings at restaurants or conference facility I assume she means will be, an offence in terms of the regulation. Now, it can't be clearer.
See, there's a slightly difference between those two statements and the one I'm putting forward. I'm saying that if you're engaging in economic activity, that's the example I put. You purchase coffees. You're paying for something that then in the course of that you also, or during the course of that, or whatever, or complementing that, you also do what you pointed out about at the dinner table, what people do. You cannot be seen to be breaking the regulations because it's economic activity supplemented with. But this is what your paragraph 217 is talking of meeting in the place and using the place exclusively for religious activity.
That was never the intention, but let's assume that is correct. My Lord,
That's how I read it, and I'm sure I would assume that's how she read it. And she says, all gatherings in the hearing of hold, it's not very well written, all gatherings remain, all religious, all faith-based gatherings are prohibited. So her 217 is slightly wrong. She shouldn't be saying all gatherings remain prohibited, because you are allowed to gather in a restaurant for economic, when there's economic activity taking place. So it's all faith-based gatherings remain prohibited. So if you're meeting there for faith-based gatherings, not for anything else, then she would be correct. So she must have read you to mean meeting in the restaurant. In other words, it's just a location, it's just a venue.
Lord, let's assume, and nobody would go to a restaurant without paying for some food or renting the venue. There's an economic transaction. So I respectfully submit your Lordship's interpretation is a bit narrow, but more particularly, even if that were so, on that reasoning, my Lord, where you have churches with coffee shops, which is a common occurrence, what your Lordship is saying, you can't go to the church and have a cup of coffee either. But what they did is they banned you even doing that. And in fact, the regulations go so far as to say that you can't have coffee after church. Now, those coffee shops also charge money, and there is an economic transaction that takes place. The rationality, my Lord, is palpable. And what you're just doing is you're saying, if there's economics, it trumps your religious rights. That's firstly your Lordship's proposition, seems to be your Lordship's position, which I'm going to address further. But more importantly, it's irrational, because what you're saying is if I have a cup of coffee, I can pray. But if I don't have a cup of coffee, I can't pray. Lord, there's no rational connection between those two. And I'll show you, Lordship, how His Lordship Mr. Justice Plaskett dealt with this kind of situation in the Essau judgment, and how what the rationality test in fact is. And there needs to be a proper basis, and the minister needs to give what that basis is. But I will come there, my Lord. So dealing with, firstly, the religious right and how people worship. Your Lordship is with respect saying, when your Lordship says that we can, surely prayer is the most important and people don't need to gather. Your Lordship with respect is making exactly the same mistake that the minister makes. What the minister tells people to do is how they must worship. And that your Lordship will find at 009-16, paragraphs 38 and 39. I know your Lordship's being directed there, but what it says is, the regulations do not interfere with religious convictions and beliefs. They merely temporarily prohibit faith-based gatherings in a physical setting. Where there are holy texts, she tells us, she knows the Bible, my Lord, that command people to gather, it must be that these texts or scriptures envisage exceptions to the rule in situations where it's not safe for people to gather. Lord, with respect, that's the same presumption your Lordship appears to make. But that's not what the holy texts say. Our response, my Lord, you'll find at 010-42, paragraph 82.
Just refer me to it.
010-42, paragraph 82. Is your Lordship there yet?
I'm there.
Thank you, my Lord. Your Lordship will see that what it says is in response. It says it's fundamental to many beliefs, including that of Christians, Muslims, and Jewish people. Your Lordship's heard from my learned friend, Mr. Botha, that they must gather physically. It is not for the Cogta minister to suggest how these scriptures should be interpreted. She's neither an expert in the field nor otherwise qualified to do so. It's not even for the court to interpret these provisions, as it would contradict the well-established doctrine of non-entanglement. And I'm going to take your Lordship there in a moment. In any event, as stated in my founding affidavit, the scripture not to forsake the gathering of the saints in Hebrews 10, verse 25, was written exactly in a time when it was unsafe for believers to gather, precisely because they would be persecuted in the form of threat to their lives and their goods. My Lord, that passage of scripture, to give your Lordship the context, and this is why it's dangerous for the minister to be presumptuous and to say things like she said. And that's why the courts don't interfere with that. The simple text in the simple passage, it says at verse 24, let us consider how to stir up one another to love and good works, not neglecting to meet together as is the habit of some, but encouraging one another, and all the more as you see the day drawing near. What you'll see later, my Lord, in verse 33, it says you will be punished. These are things that are going to happen. And it says in verse 34, for you had compassion on those in prison, and you joyfully accepted the plundering of your property, since you knew that you yourselves had a better possession and an abiding one. The context of that scripture is that by helping others and visiting people in prison, they were arrested. They were told that if they gathered together, they would be arrested. Nonetheless, the Apostle Paul writes to the Hebrew church, and he says to them,
what are you reading from?
I'm reading, my Lord, from the scriptures. But the founding affidavit refers to Hebrews 10, verse 25, and all I'm giving your lordship is the context. And that is why it is very dangerous for the minister to presume how people should conduct their religious activities. She cannot dictate, the law says, and I'm going to take your lordship there now, as we say in paragraph 80.4, how they should express their faith. She can't do that. That's the fundamental difference between the separation of church and state. The main issue is that there are less restrictive means, and this is the section 36 inquiry, my Lord. This is where it comes down to. There are less restrictive means to achieve the purpose of the DMA and the regulations, as far as the purpose is to slow the spread of the pandemic and to save lives in a manner that does not unduly infringe fundamental rights. I want to leave your lordship with that. That can be no other purpose. That's what SR says. That's the purpose of the regulations. That's what they themselves say. They've got to slow the spread of the pandemic. What they've got to do is they've got to deal with it, and they've got to save lives in a manner that doesn't unduly infringe fundamental rights, my Lord. That's what we respectfully submit, the definition and the purpose that you've got to read in the DMA. Now, if your lordship has regard to what the submission I've just made, we've uploaded a case, a judgment by his lordship, Mr. Justice Ponnen, in the Supreme Court of Appeal, paragraph 39. It's the matter of De Lange, give your lordship this full citation, De Lange versus Presiding Bishop, Methodist Church of Southern Africa and another. 2015, Volume 1, South African Law Reports, 106 SCA. It is also been uploaded, my Lord, in case lines, and your lordship, I'm directing your lordship to the page as we speak. It's at 0052273. At paragraph 39 of that judgment, it tells your lordship in dealing with these matters, it's the principle of non-entanglement. It's not it's a foreign court principle as well, international principle. Courts do not interfere with the beliefs of people, nor do they dictate what they should believe, because that's a fundamental interference with their religious freedom. So at paragraph 39, it said, I've directed your lordship to the page, as the main dispute in the instant matter concerns the internal rules adopted by the church. Such a dispute, as far as is possible, should be left to the church to be determined domestically without interference from a court. A court should only become involved in a dispute of this kind where it's strictly necessary for it to do so. Even then, it should refrain from determining doctrinal issues in order to avoid entanglement. It would thus seem that a proper respect for freedom of religion precludes our courts from pronouncing on matters of religious doctrine, which falls within the exclusive realm of the church. So it's not with respect for the minister, or indeed for your lordship, to tell religious people how they should exercise their religion and what is appropriate and what is not. Otherwise, you negate the very basis of religious freedom. So, my Lord, brings us to the Constitution. I'm arguing this all in the context of what does this fundamental religious right entail? What does it mean to have the freedom of religion when it is spoken about so eloquently in the Constitution?
Well, can I ask you this question on this?
Yes, my Lord.
If she was to say, I'm allowing it with restrictions, as she's now saying, is she interfering with their rights on how to practice their religion?
She is, my Lord, but she's doing so on a rational and legal basis based on the Section 36 test of the Constitution.
And you're saying in the second scenario, she passes the Section 36 test?
She does.
In the first one?
Not in the first one. And that's really the difference. So all the examples, my lord, and perhaps it's appropriate I contextualize this for your lordship now. What she has to show under section 36, and bearing in mind the double threshold test, what the minister has to show is that gathering as a church or for religious purposes or a faith-based gathering is somehow more dangerous than sitting in a taxi, sitting in a restaurant.
Is she saying that, or is she simply saying, I reluctantly have to, and you're saying I'm making this case for, I reluctantly have to concede to one practice because of the need, the necessity for people to do what's necessary to earn their living.
I mean,
in other words, they have to travel from one place to another on a daily basis,
yes,
to get onto their work so that they can put food on the table.
Yes, my lord, that may be so, and they're exercising their right under section 22 of the Constitution. And I'm going to show you, lordship, that in a moment.
Is that the one dealing with the right to practice your trade?
Freedom of trade, for instance. Many would be exercising,
etc.
Exactly. But that's one right. Now, the question is that right a non-derogable right? No, it isn't. So if you can make an exception for that right, and this is where all of the rationality arguments go, there's no reason why you cannot make an exception, and indeed you must make an exception for a far more important right. And I say that without hesitation, because that's what the Constitution says. So what you're doing is you're discriminating against somebody on the grounds of religion, which is a non-derogable right. So what she'd need to do, the Lord, to pass the rationality test is to say, and I'm going to show your lordship some further examples of the difficulty with the rationality here, because in the early part of the pandemic, from May onwards, June through July, what happened is religious meetings, religious gatherings were permitted, but you couldn't go to a restaurant. That's the minister's fatal flaw. I'll show you, lordship, that in her answering affidavit. She says in the Part A answering affidavit, religious gatherings couldn't meet. What are you moaning about? You couldn't previously meet. They could. And then later she opens restaurants and gyms. Now, having done that, how can she rationally suggest that there's a change of circumstances without giving your lordship the facts? It's not a policy issue. It cannot be, because she hasn't said so. She hasn't relied on the economy. She has to give a rational reason for the change in circumstances. Absent such rational reason, her conduct must be irrational. More so, where you're dealing with a fundamental human right to worship. As my learned friend Mr. Botha so eloquently explained it, given his own personal circumstances. But what does the Constitution give us? And this is important, my lord. The Constitution gives us at section 15, sub 1, everyone has the right to freedom of conscience, religion, thought, belief, and opinion. But it doesn't end there, because we also have section 31. And insofar as your lordship suggested that you can't gather because you must pray in quiet, with respect, the Constitution says something else. It says section 31(1) says persons belonging to a cultural, religious, or linguistic community, a community, my lord, may not be denied the right with other members of that community, cannot be clearer, to enjoy their culture, practice their religion, and use their language. Lord, it is inherent in the Constitution that I can gather together with other congregants who believe, like I do, that Hebrews 10 verse 25 says that I'm not to neglect the gathering together of the saints, as some do. And especially when the evil day approaches, they believe those things. As my learned friend, Mr. Botha, explained, Muslims believe exactly the same thing. So in those circumstances, section 31(1) is a right that is afforded to everybody who is a member of a religious community to gather with that community and practice their religion. Now, it does say in subsection 2 that the rights in subsection 1 may not be exercised in a manner inconsistent with any provision of the Bill of Rights. But what the minister doesn't do is she doesn't come to your lordship and say, you gathering is gathering in contradiction with another right, in the Bill of Rights. She doesn't make out that case. And your lordship may seek to make out that case for her, but with respect, you cannot. That's with how these papers work. That's how court proceedings work, my lord. We have papers. I'm going to refer your lordship to the law on judicial notice. There's certain things your lordship can take judicial notice of. There's certain things your lordship, with respect, cannot. In the first matter, which ultimately went to the Supreme Court of Appeal and they lost horribly, my lord, there were two matters. There was the Muhammad judgment, and then there was the judgment, I forget the name now, off the top of my head, Liberty Fighters, my lord, matter. And what happened is the learned judge in that matter overstepped.
The beer matter. Indeed,
my lord, De Beer. And what happened is the learned judge overstepped the mark by taking into account things and making out cases for the parties that was not supposed, they didn't themselves make out. And that's why the matter failed on appeal. Whatever the judge's personal convictions about the matter were, my lord, is inappropriate. And that's why the matter was overturned on appeal. Your lordship has got to deal with what is in front of your lordship. And there are various limits to which one can take judicial notice of matters, and various limits to which one can make certain assumptions. My learned friend, Mr. Botha, read to your lordship from the Nicro case. There's a very narrow differentiation between what is common sense and what is fact-based. But where your policy is vacillating, as here, one, we submit it can't be a policy, and two, you have to rely on facts to support the so-called policy because of what they say on their own version. So, my lord, the fundamental rights that are afforded to religious people are in Section 15 and Section 31. And those go together with Section 9. I'm not going to read it. Your lordship's well aware of it, and I've referred your lordship to the judgment. Section 10, that deals with dignity. And in particular there, my lord, arrested persons. Now, what's important, I'm going to show your lordship the government gazettes that we put up. Your lordship's frozen. I trust your lordship can still hear me.
I'm here. I can hear you absolutely clearly.
I'm very glad, my lord. So what your lordship will see is that the gathering together in the latest regulations, the minister has upped the ante. She's made it a criminal offence. Previously, under the prior regulations, you could gather, the police had to come and say, break up your gathering, and then only if you refuse to break up the gathering could you be arrested. Now, under the new regulations, even having a gathering of a religious person amounts to an immediate criminal offence, and you're liable to arrest and conviction.
You're referring to the December, January.
What happened in the December, January, the ones we are attacking, my lord.
Yeah.
Those particular regulations, the police could break you up first. They had to tell you, break up your religious gathering, and then only if you refuse could they arrest you. Now, actually meeting is criminalizing it. Now that goes to the mootness.
Regulation is that?
That's, my lord, you'll find in the supplementary affidavit, which we put up. I'll reference your lordship in a moment. It's our further supplementary was the July one that was debated. We've abandoned putting it in, my lord, but the regulations themselves are before your lordship. And you'll find them, they're DZ1 and DZ2. I'm directing your lordship to the page. It's 011366. And your lordship will see in the 27 June regulation and the subsequent 11 July regulation, which your lordship finds at 011-390. In those two regulations, she's now criminalized meat gathering for religious purposes. In those circumstances, my lord, it can hardly be suggested that this case is moot. But I was addressing this point in a different topic. I was addressing the topic on the basis that, in fact, my lord, I'm going to direct your lordship to the page to demonstrate to your lordship the 11 July one.
Can you just give me a second to read this one first?
So 011395, that's the 11 July Gazette.
Can you just give me a second to go through that? Yes.
Your lordship will see at 395, at subparagraph 19, a convener of a faith-based religious, social, political, or cultural gathering who fails to comply with subregulation 2 and 3. 2 and 3 is you can't meet, commits an offence and is on conviction liable to a fine or imprisonment for a period not exceeding 6 months or to both such fine and imprisonment. Sub 20 says a person who attends, not just the convener, the person who attends a faith-based, religious, social, political, or cultural gathering and who knows or ought reasonably to have known or suspected that it's prohibited, commits an offence and is on conviction liable to a fine or imprisonment for a period not exceeding 6 months or to both such fine or imprisonment. Now, 18, which precedes it, says an enforcement officer must, where a gathering in contravention of the regulations takes place, order the person of the gathering to disperse immediately, and if the person refuses to disperse, take appropriate action which may be subject to the Criminal Procedure Act, include the arrest and detention of any person at the gathering. That provision is the same as under the old regulations. The new ones are 19 and 20. And that is the same, my Lord, even under the June regulations. So when I submit to your Lordship that she's up the ante, this is not rhetoric. It is very, very, very serious. If you convene a religious gathering, it's a crime. So what she's just done, where people now have a conviction of their religion, she's just criminalized you doing so. That's what she's done. And there's no second chances. It is an immediate
when you
fine.
say that this is the point that Mr. Mukhagabe objected to, we're not going to be looking at the July regulations.
No, my Lord.
Except to say that it's not moot.
Precisely. And that's why I'm making the argument in that context. But what I'm submitting to your Lordship.
Does the July 2021 regulations have also been superseded?
Yes, they have. Because we keep moving through different regulations, and I'll address that on the topic of mootness.
And this particular two sub-regulations no longer.
Well, they're alive if we go back to that level, unless there's an adjusted level, and it depends on what the minister does with them.
So they don't prevail at the moment.
No, well, not at the moment, my Lord, because we're not at that level. We're no longer under this level because we were set free after July, and I'll show you, Lordship, that in a moment. If you've got a difficulty, my Lord, and in fact, I'm getting a message from my junior that they may still be alive if you traverse the 750 number inside at the moment and 2,000 outside limit. But I'll get them to check that. But all I'm submitting to your Lordship in this context.
Level 3, just at level 4.
Exactly, my Lord. This is at this adjusted level, and I'm going to submit in the context of mootness that, as is said in our learned friends' heads, the heads for the minister, at 054-90. It starts at paragraph 4, in fact, at page 89. She says that it's complex, and that's why they've introduced the risk-adjusted strategy. I don't want to take myself out of my stride, but it's obviously a point that's relevant for your Lordship. But it goes to the mootness argument. I was going to raise it in a different context. But your Lordship will see at paragraph 5, they say the philosophy underlying the RAS, the risk-adjusted strategy, is that by employing different alert levels, government is best able to ensure the appropriate restrictions are in place to limit the transmission of the virus, while at the same, which I presume they mean time, minimizing any incursion into people's lives as far as possible. For this reason, government has not merely imposed the harshest alert level, level 5, for the duration of the national state of disaster, despite the fact that this would undoubtedly result in low transmission rates. Instead, mindful of the social, my Lord, she doesn't say economic, social and economic consequences of harsh restrictions, it is engaged in a careful and orchestrated balancing act by frequently adjusting alert levels to introduce the appropriate restrictions necessary to protect the public and slow the transmission of the virus while trying to minimize undue restrictions. That's the balance which I said to your Lordship with reference to our answering affidavit. That's what my learned friends say in their heads on behalf of the minister. It's a balance. So to argue this is moot, once we could go back into that, and that's what his Lordship, Mr. Justice Plaskett, said. He said, this is still alive. We can go back up and down. The only one he said wasn't alive was the one about clothing, because they abandoned that one and never went back there again. And so he said, I don't have to address that. But he addressed the hot chicken dinners and the exercise, as I'll show you, Lordship, in due course. But what I'm submitting to your lordship in the context of practicing your religion is that this right, constitutional right of freedom of religion, and what the minister is doing here, as we said in our founding affidavit, doesn't just implicate sections 15 and 31. It implicates the right not to be arrested, and it implicates fundamentally dignity, my lord. I'm not going to repeat the arguments of dignity because my learned friend Mr. Botha did that so well. But what you can see is that there's no greater invasion of your dignity than in arresting you for practicing your religion. Especially, my lord, and your lordship would know this, your lordship would take common sense of judicial notice of. Religious people, by definition, means people who obey laws, because that's what religion means. We all have different laws depending on our religion, but it's inherent in people who practice religion that they want to obey the law. If there were doubt about this, we address it in our papers, my lord. But Romans chapter 13 for Christian people is fundamental. Romans chapter 13 instructs Christian people to be subject to the governing authorities. It literally reads, let every person be subject to the governing authorities. For there is no authority except from God, and those that exist have been instituted by God. Therefore, whoever resists the authorities resists what God has appointed, and those who resist will incur judgment. For rulers are not a terror to good conduct, but to bad. Would you have not fear of the one who is authority? Then do what is good, and you'll receive his approval. My lord, the point is simple. This person now has Hobson's choice. Now, it may seem that in these holy scriptures there's a contradiction, but it's an easy contradiction to deal with. Where the Lord commands you to do X, you do X. If government commands you otherwise, you suffer the punishment. The moving of your goods, practicing your faith, that's what you do. But otherwise, every authority under God's authority, in other words, obeying God's laws, must be obeyed. So what you do is you put a religious person in Hobson's choice. They are instructed to obey the laws. They're not people who willy-nilly just go and do things. We know that by definition. Lord, we uploaded another document to case lines. And this is something I respectfully submit when I deal with judicial notice, your lordship can take judicial notice of. It's a letter from the president to the whole country. And what the president says is he tells in this lengthy letter, he gives the example of Martin Luther, which is he commends the religious community and says you're acting just like Martin Luther did, which was on the one hand to keep people safe, to fumigate houses, take medicines, protect people, but at the same time, you're supporting people with your faith. That's the example he gives. It's a passage written 500 years ago, my lord, that he quotes. He says that in many ways, the views expressed by Martin Luther 5 centuries ago echo the position of religious leaders in South Africa in the midst of the current pandemic. He says faith-based organization being vital to our national response to the disease, not only providing spiritual comfort and guidance, but also by caring for those most vulnerable to the effects of the pandemic, including through the provision of food, shelter, and other social services. Religion plays an important role in the lives of millions, my lord. It's not dealing with some minority here of South Africans. And congregational worship forms a vital part of their religious practice. The government knows this. The president knows this. And he explains that. And he commends them for being constructive and for them being assistive and for them helping people. And that those are the people that religious people are. In fact, what they do is they encourage people, as he says in his letter, to obey the law. Now, this gets to, and I'm traversing a number of different grounds, but it's convenient to address it now, my lord. The second set of regulations, those that were attached, which we said were missing on the 14th of July, same date of our supplementary, of course, we didn't expect that to happen, and they then filed those regulations. We expected the minister to include them, the minister doesn't. My learned friend says, oh no, those are not relevant because that doesn't deal with the pandemic. He says in his argument that it deals with a different issue because he says that deals with the riots. Well, here's the actual farce about that, my lord. Those regulations, and I'm dealing with this in the context of religious people being law-abiding citizens. That's what I'm submitting to your lordship, is that they are inherently law-abiding. If that were not so, why would the government ask those same religious people to convene meetings of community meetings in the middle of the riots? It's to deal with the emergency situation, to bring calm. to allow people to say, well, you can't do this anymore. Lord will find the Government Gazette as passed at 011-472. That's the first one. It's DE2-3, 011-472. My Lord, I've directed your Lordship to the page. Your Lordship will see there that the first regulation, there's 2 regulations passed on the same day. It says gatherings at community engagements hosted by members of parliament, members of provincial legislature, councillors, leaders of political parties, religious leaders and traditional leaders to deal with emergency matters are permitted. So in the middle of these regulations, which I just showed you, Lordship, where you can get arrested for a religious gathering, the religious minister is now to convene, because we have riots 3 days later after they've promulgated the 11th July. Now the religious leader, who's obviously a leader, obviously conscientious, otherwise why would they put him to convene this meeting? Obviously law-abiding, says you can have such a meeting. Now that wording, obviously the minister thought that was too vague, because the minister shortly, probably a couple of hours, whatever it was later, but the same day, passes another regulation. And your Lordship will find that a few pages on at 011-474. I've directed your Lordship to that page. Now you'll see that the wording changes. Now this is where my learned friend Mr. Mogabe's argument clearly was not correct, my Lord, because he said this is to deal with the violence, and he only read your Lordship the first regulation. The first regulation says the violence. Now let's look at the confusion that comes with the second regulation. 4A. She deletes the previous one that she just passed the same day. She says gatherings at community engagements. So now you can gather. The same people that religious leaders would normally gather in their churches or in their mosques or in their synagogues can gather. They permitted. If you are religious leaders to deal with emergency matters, now they say emergency matters that impact on, what do they impact on? Management, treatment, and prevention of COVID-19 pandemic are permitted, subject to a limitation of 50 persons or less, and if the relevant space is too small to hold the prescribed number of persons observing a distance of at least 1.5 meters from each other, then not more than 50% of capacity of the space may be used, subject to strict adherence to all health protocols and social distancing measures. So now, funnily, now you can meet to discuss COVID in a church with a community gathering, with a religious leader leading this up to discuss that. But you couldn't do it 3 days earlier, and you can't actually get to church on a Sunday unless you're going to preach about the COVID-19 pandemic. Now, Lord, with respect, what would a religious leader say to the people? The context is the riots, but look at the way they've changed the regulation. What is he going to tell people? Why does the government rely on him? Because religious people are inherently law-abiding. So what does he want them to do? He wants to say, would you tell everybody to obey the law? Now, why would a religious person do that? Because I've just read your Lordship Romans 13, and I've no doubt my learned friend Mr. Botha would be able to quote your Lordship passages from the Quran which would say the same thing. You must obey the law. So now we've got religious people that are called upon by the government in the middle of the pandemic. We have in the supplementary affidavit, Lord, of the minister, which she presents, you have a graph. That graph, my Lord, we'll find at page 011-445. I'm directing your Lordship to the page.
Yes.
This gives your Lordship the various waves that the parties went through, or that the country's gone through. Now, they cut that off in the second wave, 10 November 2021. But your Lordship will know that on the 14th of July, this graph comes from Google, my Lord. If you just Google this graph, you'll get the same one. What we put up in our supplementary affidavit is the updated graph. That's the one that they didn't want in. Your Lordship will see if you simply Google COVID stats SA, you will get the exact same graph. But what it'll show your Lordship is that when this happened, it was at the height of the pandemic in July of this year. And your Lordship will see that this graph does cover this year, in fact, on my mistake, my Lord, it does cover this year. But your Lordship will see the third wave is in this graph. Your Lordship will see that the bottom of the wave is 20 May, 15 August is the bottom. If your lordship goes to Google and looks at where we were on the 14th of July, we were at the height of the pandemic, where we had daily cases in excess of 17,489. We had just passed the peak of infection. Daily cases. Today we're at 600 or something. 17,000 was the 7-day average, 17,781. My lord, in the middle of that, who do they call upon to help them because we have riots and looting on the streets? In Mr. Mokgakabe's own words, the religious leaders. Now, for a religious leader to face being arrested if he has a gathering on a Sunday to preach a message, as opposed to gathering the same people to tell them that Romans 13 says he must obey the law, is clearly irrational. But it is a clear invasion of his dignity. I'm dealing with this in the context of Section 10 of the Constitution. It is a religious leader being arrested, my lord, is undignified. People may put being a martyr on a pedestal, but it's hardly something you want to do. As a religious leader, being arrested for disobeying the law. Lord, that is the context.
Finally, Tutu did it so many times. In my,
I beg your lordship's pardon?
Bishop Desmond Tutu and others did it so being arrested publicly all the time in my time.
Indeed, sir, my lord, because they stood up for what they believed in. And they stood up for what they believed in. And his lordship, Mr. Desmond Tutu, Bishop Desmond Tutu, and Archbishop Emeritus, I think that's his title, is such a good example of what the religious Hobson's choice is. Because you act according to your conscience, and you do what is right according to your conscience, but more importantly, your conscience is directed by your belief system. And that what then happens is you end up being arrested by this government and because of these regulations. Finally, my lord, just on the Constitution, Section 39 deals with the interpretation. And I'm going to just draw 2 points, 39(1)(b). Well, 1A, of course, says must promote the values that underlie an open democratic society based on human dignity, equality, and freedom. The fundamentals, human dignity is right there. Sub B must consider international law, and sub C may consider foreign law.
My lord, may I just intervene, my lord?
Sure.
I have been raising, my hand, my lord, for almost 15, 20 minutes.
I'm so sorry. I've been looking at the document. Thank you.
Yes.
My apologies. I've been looking at the documents they're referring me to.
In fact, my lord,
I'm not watching the screen of
yes,
the proceedings.
I have the purpose, my lord, was just to object to what Mr. Botha has been submitted to the court relating to regulations which are not the subject matter of these proceedings. My lord, as your lordship has argued,
and I'm taking note of that.
And it's not only for purposes of mootness, my lord, but it's for purposes of other aspect of the case, my lord. So, and interpreting these regulations, my lord, it is not proper for them to do so, my lord. The regulation not before the court. If it's for, it is not for mootness, my lord, because the way it has been argued, my lord, before the court.
Yeah, okay, for the sake
making
of
a distinction between, yes.
For the sake of avoiding getting into an unnecessary skirmish that will detract us, I'm going to now ask Mr. Botha to move on. I think the point has been, you can just move on.
I was going to move on, my lord, and I've dealt with the issue, and we will stick to mootness. It doesn't matter, my lord. If I may refer your lordship to our heads of argument.
How much longer do you have, Mr.? How much longer will you be?
Oh, my lord, I will be at least another 45 minutes, I would suggest.
That's 2 hours you're taking.
Yeah, I did warn your lordship up front because of the nature of the questions your lordship posed. And the issue, your lordship, my lord, with respect, what I've dealt with, nothing I've dealt with is irrelevant, and I haven't repeated anything said, but I'm addressing your lordship's question, where your lordship says that religious people can practice their religion in their own bedroom and they're not allowed to gather because the minister says so. With respect, I have to address those arguments, my lord. I can't be curtailed from addressing those arguments.
Okay, if you want to take that long. Mr. Mokgakabe? We're going to obviously, it's going to obviously take a bit longer.
Yes.
I'm going to ask you to be a bit more succinct and less over-explanatory.
As your lordship pleases.
So make your points, but without they come across. We don't, you know,
As your lordship pleases.
Excessive explanation for them. So I'm trying to get you to, but we're going to have to adjourn, of course, and come back. And maybe that'll give you an opportunity to look at the points you want to make and see how you can. It's more difficult to reconstruct your argument while arguing. It's easier to reconstruct it while you have a few bit of moments on your own of reflection.
As your lordship pleases. I will keep it more brief, my lord.
Okay, so can we then adjourn now, and we'll come back in half an hour? What is the time now?
It's 1 o'clock, my lord, or 2 minutes past 1.
1:30 we come back.
Thank you, my lord.
And Mr. Mokgakabe will start from there, and then we might adjourn again at 3 for a short while to see how long Mr. Mokgakabe is. And then see, we'll carry on till the end of the day for Mr. Mokgakabe. And if he needs to continue, he'll continue tomorrow. Mr. Mokgakabe?
My lord, I'm indebted to your lordship, my lord. I will try to be as expeditious as possible, my lord. I mean, in dealing with all of these issues, my lord.
Yes, they've raised a lot, and you got a lot to answer to. So
I have a lot to answer, my lord.
you're not going to be restricted. That I can assure you.
Yes.
Okay. So we'll.
But I'm not gonna raise issues which are not before the court, my lord. Definitely,
Yes.
my lord.
Yes, and you just point out which.
I'll just point out.
And say we must ignore those issues.
Thank you, my lord.
Thank you, my lord.
So we'll start at 1:30.
Thank you, my lord.
Court is adjourned.
I can now jump to, having set the stage, I can jump to our heads, which I would ask your lordship to turn to page, well, your lordship doesn't necessarily need to go there, but, and I'm mindful of time, my lord, but 054 -9 in the heads of argument. So it's 054-9 or -9 from paragraphs 11 by heads of argument, my lord, onwards to paragraph 19. What we do there is we describe what the nature of this constitutional right is, my lord. What's important is the right entails, as I've expressed to your lordship, the right as per S versus Lawrence to entertain such religious beliefs as a person chooses, the right to declare those religious beliefs openly without fear of hindrance or reprisal, and the right to manifest religious belief by worship and practice, by teaching and dissemination. We deal, my lord, with the Swiss Constitutional Chamber, which reference the International Covenant on Civil and Political Rights, that deals with the religious freedom, both the inner freedom to believe and the outer one to express those convictions and to practice them, very importantly, my lord, and includes the right of everyone to behave in principle according to the teachings of their faith and to act in accordance with their convictions. So, my lord, the fundamental practice, the point we make at paragraph 13 of most religions is meeting and gathering, and as I've pointed out to your lordship, section 31 sub 1 encapsulates that right. So, as is the case, my lord, at paragraph 14, and this is important, this relates to the question your lordship posed to my own friend, Miss Martin, as to how far this right goes. The court has expressed itself and explains this very clearly. In the Christian education case, my lord, your lordship will see that from paragraph 14 of our heads. It's not to say that that religious rights can't be limited. Of course they can be limited, like all rights, in appropriate circumstances. But of course, at that test, it must pass constitutional muster, my lord. And his lordship, Mr. Justice Sachs, writing for the unanimous Constitutional Court, describes that test in the context of section 36, and we've quoted it at 054-11 of our heads. So to sum up, the learned judge says, limitations on constitutional rights can pass constitutional muster only if the court concludes that considering the nature and importance of the right and the extent to which it is limited, such limitation is justified in relation to the purpose, importance, and effect of the provision which results in this limitation, taking into account the availability of less restrictive means to achieve this purpose. We've highlighted that, my lord, by underlining it. That's actually what this case is about. The question is, what are the means that can be used, and are there less restrictive means available? Though there might be special problems attendant on undertaking the limitations analysis in respect of religious practices, the learned judge is recognizing what I've just submitted to your lordship, the entanglement, the nature of these rights, etc. The standard to be applied is the nuanced and contextual one required by section 36 and not the rigid one of strict scrutiny. So that's why we submit to your lordship. That's what this case is about. Here we're obviously dealing with a balancing exercise we submit, as we've pointed out in the heads. It's the balancing exercise contemplated in section 36, and his lordship, Mr. Justice Sachs, again, after considering the context of religious freedom, says, accordingly, believers cannot claim an automatic right to be exempted by their beliefs from the laws of the land. At the same time, the state should, wherever reasonably possible, that's the test, wherever reasonably possible, seek to avoid putting believers to extremely painful and intensely burdensome choices of either being true to their faith or else respectful of the law. So what we respectfully submit, my lord, at paragraph 16 is reasonably possible, despite the pandemic, is not to unreasonably limit people from practicing their religion safely, in the same way that people during the same time period were not restricted from carrying on their other activities, especially the permitted activities. Those are the activities we've defined above, my lord, going to gym, going to a restaurant, etc. And they're all categorized. You'll see that the minister has consistently categorized them together in the various regulations over time. When she opens the one, she opens the other. It's the inconsistency that arrives, for instance, in these regulations, where in December initially everybody was locked down. When the January regulations came, they opened up restaurants and they opened up gyms, but they didn't open up for Christian services. And so, or for any other religious services and faith-based gatherings. So, my lord, it's at that point where we respectfully submit, it's that complete failure by the respondents to take into account the availability of less restrictive means to achieve the purpose of the DMA regulations in order to deal with the COVID-19 pandemic that gives rise to the present challenge as a result of the complete ban. This application was accordingly launched in that background. And then we quote for your lordship the Dwayne Esau, I think it's how they say it, Esau case, where the learned judge says, even in times of national crisis, as this undoubtedly is, the executive has no free hand to act as it pleases. All the measures it adopts, it must adopt measures to meet the exigencies that the nation faces, must be rooted in law and comply with the Constitution and the rule of law, my lord. That's the point he makes. That's not different to the international cases. And your lordship will see the statement of his lordship, Mr. Justice Gorsuch, in the Roman Catholic Diocese of Brooklyn case versus Cuomo. Even if the Constitution has taken a holiday during the pandemic, it cannot become a sabbatical. And that's what we have. Now, that case, we're going to commend it to your lordship. It's part of our bundle. Lordship will find that in that case, what they do is they set aside, precisely because of this distinction between economic activity and the activities of religious gatherings. And they say it's not rational, it's not justifiable to have that distinction. And we respectfully submit that the position is no different in our law.
Can that be right? I mean, the mere fact that you're trying to provide someone with the opportunity to continue with acquiring the means of living is slightly, is in their view, not different at all from someone that's meeting to pray.
Lord, that's what the Supreme Court...
I know there's the spiritual element which is necessary for people to survive, but does the fact that someone's earning a living not make it slightly different?
Lord, I'm going to address the earning of the living in the next paragraph. I'm just commending the judgment to your lordship, but that is what the majority of the Supreme Court in the US found. And we respectfully submit that that is so. And again, the economic test is not necessarily the one that the minister is putting forward, but I'm going to deal with that separately in a moment. Just under this heading, I'm going to just commend to your lordship just also the content of the religious right. I'm not going to take your lordship there in detail, but your lordship will find the Pillay case, it's been referred to by several others, And what the Pillay case, it's at 055-789 of our authorities bundle, 055-789. And what it does is it sets out the content of this right and how, even though the school said in that case, why can't she just take out her nose ring during the day? And the court found that that's not a reasonable accommodation in those circumstances. And the court found that she needed to be accommodated. So, my Lord, that is the balancing of those particular rights and the importance with which our courts have held them to be. So, my Lord, ultimately, I would also commend to your Lordship 05439, which is our heads of argument, just for purposes of expedience, 05439, paragraph 74. Your Lordship will see there that we deal in even more detail with the nature of the fundamental rights, and we again deal with international jurisprudence in regard to the contents of those rights. And sorry, paragraph 78 onwards, Your Lordship will see. So that's 05439, paragraph 78, and we deal with that in more detail there, and I'm not going to detain Your Lordship any further. I've summarized the position in our respectful submission. What that brings me to, my Lord, and I'm going to come to the economic point in a moment, but the other point Your Lordship raised is that the ban is temporary. Lord, what we respectfully submit in the light of His Lordship Mr. Justice Sachs' judgment in the Christian education matter, that is partly bound up with a reasonable test, reasonableness. Could this be achieved in another way? That's where we are. And I'm going to take Your Lordship in due course to the SR judgment, where you have a short circuit breaker, I think as they called it internationally, where you put a stop and everybody has to stay at home. That's perfectly understandable. It's not ideal, and I'm sure many religious people wouldn't rely on it, wouldn't find that a happy circumstance. But where you're being treated the same as everybody else, that's one thing. It's when you have a circuit breaker and then you open up to other activities, but not to religious activities. And that's where the duration comes in. But bearing in mind also that even a temporary ban is still an infringement of the right. It's still an infringement of what is a fundamental right. And to those who practice their religion goes to the heart of it. And bearing in mind, my Lord, and we make this point in our papers, and it's made even more in the SAN's NCF papers, which we incorporated those submissions by reference. Many people in this population don't have Wi-Fi, don't have internet. It's all well and good telling people watch on TV or watch online. That's not possible. So for many people, when you say, even if it's a temporary ban, you are absolutely excluding them from practicing their religion and gathering together. And that goes to the indignity of it all, my Lord. And it is indeed not only an affront to a religious person, as Mr. Botha submitted, to watch somebody go and gamble next door when you can't go to church, but it gravely impairs the sense of justice, equality, and dignity of that person. Lord, do not address the issue of the economy. Our first submission in this regard, my Lord, is with respect, Your Lordship is asking the wrong question. Your Lordship says, isn't this a matter of balancing the economy and dealing with religion rights? And Your Lordship is, with respect, elevating Section 22 of the Constitution, the right to make a living, above religious freedom rights. They're both constitutionally protected. Let's assume they were of equal weight, which they aren't when you discriminate against somebody on the grounds of religion under Section 9. But even if they were, why treat me differently? If they're both fundamental rights, you'd need to give a very sound reason why you don't treat people the same. And I'll deal with the rationality in due course, but just dealing with it at a fundamental principle level. If you were to compare the two in the scheme of the fundamental rights provisions, we respectfully submit that Section 15(1) in fact trumps Section 22. But even if it didn't, what justification can there be to give effect to one right whilst excluding the other? But the correct approach, my Lord, with respect, is the one that His Lordship Mr. Justice Sachs said. There is a right to practice your religion. That right is being infringed. not only is it that right that is being infringed, but it is your right to equality and dignity and to be equally treated before the law that is being infringed. Once that is infringed, the question is whether that right may be limited under Section 36. Now, SR, my lord, your lordship will find in our authorities bundle, and I'm going to refer to it quite extensively, we've inserted both the ARCO judgment and the Supreme Court of Appeal judgment. But the Supreme Court of Appeal, you'll find it 055-443. So from paragraph 106 of that judgment onwards, your lordship will find the test in dealing specifically with these regulations. Now, amongst others in this context, the learned judge is referring to procedural rationality. My learned friend, Ms. Engelbrecht, has already dealt with the issue of whether this is administrative law or whether it is a legality challenge. It doesn't matter because his lordship analyzes the case on both. But the finding is, in this case, that it is PADJA, my lord. And ultimately, for that reason, we submit that your lordship's bound by that decision, whatever our learned friends may submit. But from paragraph 106 of the judgment, his lordship begins to explain Section 36 of the Constitution, and we commend it to your lordship. And from 108, he explains that the determination of the constitutionality of the impugned regulations involves a two-stage process. First, the appellants are required to establish that the regulations infringe one or more of the fundamental rights. My lord, that's established. It's clear. Secondly, if they succeed in establishing this, the burden shifts to the respondents to justify the infringement or infringements in terms of 36(1) of the Constitution. Now, of course, here there's that double threshold, which I've referred your lordship to, Mr. Botha has. But if they fail to do so, the offending regulations must be declared to be invalid to the extent of their inconsistency with the Constitution. If it is just and equitable to do so, a court may limit the retrospective effect of the declaration of an invalidity or suspend it for a period to allow the competent authority to correct the defect. Lord, I've noted in my learned friends' heads, or shall we say the minister's heads, that there's a suggestion that there should be some kind of just and equitable remedy here. That argument can't live with the mootness argument. Your lordship will make a declaration of invalidity. You'll say that they were irregular. They have every opportunity under the next round of regulations to pass valid regulations. There's no need for a retrospective or a limiting of the retrospectivity because on their version, they're no longer alive. But at the end of the day...
In your understanding, the order, if you win, would simply be a declarative.
Exactly.
The regulations, the two impugned regulations were unconstitutional.
Indeed, so, my lord. That is our respectful submission. A learned judge explains that if the respondents justify their infringement or infringements of the fundamental rights, then the regulations are valid. Their impact on the fundamental rights have been sanctioned by the Constitution. So that's the test, my lord. So to start with, worrying about economics or otherwise, my lord, is not the appropriate test. The test is to measure it against, has there been an infringement? And then it's up to the minister to go and explain to your lordship why that infringement is justifiable under Section 36. Now, the real question your lordship will have to deal with is, has the minister discharged that onus? We submit not. And I'll demonstrate to your lordship in due course why not. But the question that is asked before that is, how does she discharge this onus? And his lordship, Mr. Justice Plaskett, tells us this too in this judgment at paragraph 146. Where he is now dealing, your lordship will note that he deals with two aspects. He deals with a number of aspects. He deals with procedural regularity, and I'll deal with that, touch on that when I deal with consultation. But from 144, he deals with the exercise regulation. Your lordship will recall that people were limited to exercising at certain times in certain places and certain types of exercise. And the learned judge says at paragraph 146, no attempt has been made to justify why only 3 forms of exercise were permitted. It's difficult to imagine a rational reason. Why, for instance, should a person not be permitted to exercise by canoeing or kayaking on a river or a dam? Why should a person not be permitted to exercise by swimming in a dam or river? Similarly, no reasons have been given to justify why people were restricted to taking exercise within 5 kilometers of their home. Why should a person not be permitted to travel 6 kilometers from home to hike in the veld or up a mountain? In the absence of explanations, this is the important part, for these limitations, I find there is no rational explanation to justify them. The result is that no rational connection has been established between restrictions and their ostensible purpose. They are also disproportional because their necessity has not been demonstrated, nor is it obvious or explained. Now, my lord, the learned judge refers in footnotes 137 and 138 to other authorities where that point is elaborated upon, but he has succinctly stated the point. All that you've got to do is that the minister has to do is they have to give a justification. They have to explain why the one way or the other. And there needs to be some explanation. Now, the minister cannot discharge an onus where the minister hasn't given your lordship reasons. The only reasons with respect, my lord, as the minister herself says, when we ask for reasons, is in the answering affidavit to Part A. She says, those are your reasons. And she limits herself to those reasons. Because when we ask her for reasons after Part A is postponed, as we're entitled to under Rule 53, she says you can't have any. And I'm not giving you any. So whether it's under padger or illegality, and my learned friend will no doubt submit, because this is some kind of polycentric, they allege, we'll address that, polycentric argument that they don't have to give reasons, that's wrong. Because we've submitted in our heads and we've given your lordship case law that says even in the case of illegality, you have to give a reason. Otherwise, how does the court judge whether you were acting rationally or not? Because even under legality, there's a rationality test. But, my lord, as I've already submitted, your lordship is bound by padger. Now, therefore, in this test, which I've just described to your lordship, the debate about economics doesn't come in. It's not to say because she's let somebody else out, now there's there's some kind of weighing up of that exercise. No. What the relevance is of these other activities being allowed is that they demonstrate, as I've already submitted to your lordship, that there's a more reasonable way of achieving the purpose. How do you go to a restaurant and take off a mask, and you can gather with as many friends as you like, and people sit at a restaurant table right next to each other? You can take off your mask, COVID suddenly disappears while you're eating. If you pull out a Bible, or it suddenly becomes a meeting where you're dealing with religious matters, and I take your lordship's point from earlier, but with respect on that basis, on what the minister seems to say, you have coffee or a meal. Now you can't do that either. But what is the rationality of doing that? Because what should have to say, these people who abide by laws by nature are less likely to abide by the laws than somebody who goes to a restaurant and has alcohol. Now, this point, my lord, is exactly the point that is made in the foreign judgments, to say, on what rational basis can you contend that somebody in a restaurant is less likely to spread the disease? You can't. There's no basis for that basis, and that's what my learned friend, Mr. Botha, submitted to your lordship with reference to virologist and evidence. But the minister doesn't do that. The minister doesn't put up the evidence. She bears the onus. So the debate around economics is a red herring, with respect, my lord. It's not about that issue. I can let some people out. It's about, have you infringed the religious right to freedom? And can I have achieved that in a better way? And if you've let other people out who are just as likely to spread the disease, then you cannot give a justification for your restriction. It cannot be justifiable or reasonable in the balancing exercise of those respective rights. And it doesn't mean that just because you allow a religious gathering, it's not one or the other. You don't say, well, I must choose religion over restaurants. No, my lord, they can both operate at the limit of 50. Because otherwise the minister has to say to your lordship, and she doesn't say this, that there is a very high risk of spreading the disease. And sorry, somebody's not muted, my lord. Mohammed Mullah, my lord. You could just put off their microphone, my lord, with respect. Thank you. My lord, so the nub of the question is, it's not a choice between these alternatives. The question is, if the minister says that it's safe enough for people to eat at a restaurant, to sit in a taxi, safe enough for purposes of spreading the disease, safe enough. Why is it not safe enough for a church? And that's the question that the Minister with Respect never ever answers in the papers. You're left without any proper reasons, and I'll take your Lordship momentarily to the reasons that she does give. And I'll demonstrate to your Lordship that each of those reasons are only anecdotal, they're not scientifically based, and they're unsound because we're not comparing like for like. But what's more important, my Lord, is an alternative. And perhaps here I can just marry the arguments of my learned friend, Miss Martin. Your Lordship has sought to suggest, it seems, to my learned friend in imposing the question that churches have nothing to do with economics. Lord, with respect, that can never be so. Why? As I referred your Lordship to the letter from the President, what do churches do? They are the inventors of redistribution of wealth, Lord. It's not a communist or socialist idea. It happens in the book of Acts chapter 2 and Acts chapter 4. It's what they do. They provided for each other amongst themselves. It says they had all goods amongst them equally. That's what the scripture tells us. In James chapter 1, verse 27, it says, true undefiled religion before God is taking care of widows and orphans. You are instructed, not, as James says in chapter 2, you can't just tell the widow or orphan, be blessed, warmed, and healed, and not give them anything. They are fundamental to the economy as social grants are fundamental to the economy. The President recognizes that in his letter. It's not disputed that that is so. So what we have is a situation where churches are vital to the economy. That's at the one level. But there's another reason. My Lord, churches must also be distinguished between church workers. At the first level, there can be no debate that churches run activities. They have bookshops. They have coffee shops. They run businesses. They collect tithes and offerings, as SANCF explains to your Lordship. In those poorer communities, we don't have things like EFTs. They come to church and they give their money. What are these funds used for? They're used, firstly, to redistribute to those in need. But secondly, and just as importantly, they feed the church workers. Now, perhaps some people get overly pious and suggest, oh no, church workers should never be getting any money from anybody's tithe or offering. But that's naive, my Lord, and is not scripturally sound. Nobody's suggesting that the pastor is supposed to be rich and fly around in jets, as some of the notorious people overseas that we've seen. But what is clear from the scriptures is, and this goes back whether you're Jewish or whether you're Christian to the Old Testament, when the Lord called priests in the book of Exodus, and he deals with it in Leviticus, Numbers, and Deuteronomy. The Old Testament for Jews and for Christians is the same. What he does is he calls priests and he says, I'm not going to give you an inheritance in the form of land. I'm your inheritance. What people will do is they'll bring you a tithe and you'll live off the tithe. They lived off the offerings in the temple. That doesn't change in the New Testament. In 1 Timothy 5:18, it tells us, don't muzzle an ox when it treads out the grain. The laborer deserves his wages. He's explaining that in the context of church workers being entitled to earn money from the tithe and the offering. In 1 Corinthians 9:9, it says, for it's written in the law of Moses, you shall not muzzle an ox when it treads out the grain. Is it for oxen God is concerned? Does he not certainly speak for our sake? It was written for our sake, because the plowman should plow in hope and the thresher thresh in hope of sharing in the crop. If we've sown spiritual things among you, is it too much if we reap material things from you? If others share this rightful claim on you, do not we even more? Nevertheless, we've not made use of this right, but we endure anything rather than put an obstacle in the way of the gospel of Christ, he explains. What he is showing, my Lord, is that that's how ministers of religion earn a living, in inverted commas. What the SANCF application demonstrates, your Lordship, is they're not entitled to the stipends and they're not getting any support. So because of the nature and the informal nature of it, doesn't make them any less dependent on the economics. So, my Lord, there's a distinction. At the one level, there is the right to the individual and the congregant to congregate together which is secured under Section 15(1) of the Constitution and under Section 31(1) of the Constitution, clearly and unequivocally. That is a right that is unrelated to pecuniosity. It's got nothing to do with money per se, except, as the SANCF explains, that is where people get fed. They come to church on a Sunday and they receive their food. That's how these distributions happen. It happens on those gatherings. Once it's a faith-based gathering or a religious gathering, one can't separate that from a feeding scheme or otherwise. It is the same thing. They're one and the same. The people gather together and the purpose is the same. That's at the one level. But at the other level, not only do churches add to the economy by providing this food and assisting others, but more importantly, they also have to minister to those religious leaders who just don't have any money. So if your lordship puts to us that Section 22, what about the poor restaurateur? There's a distinction again between the restaurateur and his clients or customers. Those coming to eat a meal have no right to have a meal at a restaurant.
Ladies and gentlemen,
with respect,
please
you
note
can
that
search the Constitution far and wide.
We have about
You'll not
2
find
minutes
one
or so.
provision that says, I need to go to a restaurant to eat a meal. So in that respect, they are significantly in a different position to those who are practicing their religion, who have a right to attend church. But if your lordship says, open up the restaurant so that the restaurateur can make a living, a fortiori, the same thing for the minister. Not only is he performing a vital social function as conceded by the president, counseling people, advancing their interests, making sure that they are healthy. You can go see a doctor during the pandemic. You should be able to see your priest. Many people, that's more important to them.
Would that prohibition, would that be prohibited in terms of the regulation?
It is currently that's why the essential service workers argument, my lord, which I'll get to momentarily. So you can see your doctor at any time, or your doctor can come to you because he's an essential service worker. Well, as soon as we get into situations where we're in lockdown level 5, or the priest can't move, or when there's a curfew, unless your essential service worker is entitled to move, he can't move. Even the psychologist, you can go see a psychologist, and many people would consider their priest. As we know, we've got a confession, a confessional. A priest is like a psychologist. You can go see your psychologist. There's an exemption for that because they're an essential service worker, but not for purposes of seeing your priest or your minister. When somebody is dying, my lord, we all know last rites are administered. Death doesn't happen between curfew hours. Death happens whenever. And what happens is now the priest can't go and administer the last rites because he's not an essential service worker. If he goes, he will be arrested. So, my lord, that's the distinction between these different positions, is that whereas a restaurateur may have a right under Section 22, the poor Christian worker not only has that right under Section 22 to make a living, but he also is conflicted because he can't minister to his congregation, which normally happens in a congregated setting. Once that is the factual reference, with respect, even if your lordship found I was wrong in my submissions in regard to the fundamental rights test, which I respectfully submit cannot be so given the judgment of his lordship, Mr. Justice Sachs, and what SAO itself says as to how you measure it, they also have economic interests. And that's what the SANCF explains in such detail. So, my lord, a blanket ban, which is the same as going back to level 5, is very different where everybody is under the blanket ban. That's what his lordship, Mr. Justice Plaskett, describes. And in that situation, initially what happened is everybody was banned, and then we moved to level 4. That's what that case was about. But what then happens, and he says it's understandable in those circumstances that everybody is shut out. But when you start opening up, and that's why he deals with the issue of exercise and hot chicken dinners, my lord, the hot meals, he criticizes that. He says, what's the rationality of standing in a queue for a hot meal versus standing in a queue to pay at the checkout counter? Well, with respect, the same reasoning applies. What's the difference with standing next to each other and we're not allowed to pray and we're not allowed to worship? even though restrictions are put in place, social distancing, masks, they are detailed, and we put them in our papers, my lord. After May, there was a detail circumscribed. Only one person could sing. People couldn't all sing. You only were allowed to have one performer, one person playing a musical instrument. We don't attack those regulations. That's not a problem. That what they demonstrate is that one can achieve the same purpose reasonably, as His Lordship Mr. Justice Sachs says, is the test. What the demonstration is, how do you compare that to going to a restaurant? It's no worse. And if you say that it is worse, then put the restrictions in place, which is what the minister did. And when she did do that, she opened up prior to restaurants. Once that is so, how can it ever be suggested that the purpose of preventing the pandemic from spreading cannot be reached in a less restrictive manner? So, my lord, that's where the equality comes in, and that's where the equality arguments then fit in. Lord, if I can then just deal with the rationality aspect. As far as rationality is concerned, my lord, I've already given your lordship several examples. Your lordship suggested, can't recall whether it was to Miss Martin or I think it was to my learned friend, Mr. Botha. Your lordship suggested, but these things are never going to be perfect. Lord, nobody's asking for perfection. The test is set out in the SR judgment. What they have to be is rational. My lord, if they are irrational, even if some mistakes are going to happen, those ones will be set aside. That's what His Lordship Mr. Justice Plaskett does. And the whole Supreme Court of Appeal bench with him in a unanimous judgment. Petsy, Deputy President Zondi van der Merwe and Mabindla Bokwana. All of them concur in this judgment. If you've got ones where you've overstepped the bounds of rationality, you don't just take a broad brush and say, oh, don't worry, you're operating under pressure. My lord, what your lordship must remember, and this is where I started the argument. In our founding affidavit, we point out to your lordship that there is no parliamentary oversight. There is nobody here that's going to act as a check and a balance to the minister who's exercising this executive power, she calls it, or under administrative law, other than this court. Nobody else. So she becomes a law unto herself unless the courts are the check and the balance. And that is why, not only on the rationality, but relevance to mootness, your lordship has to declare things done which were unlawful, because nobody, Parliament doesn't interfere. That's the big argument. There are pending bills in Parliament where, amongst others, the Vryheids Front have suggested there be a move to that. My lord, that is what they did in the UK. They put up special legislation to deal with the pandemic, but it still has parliamentary oversight. This has no oversight whatsoever. The only oversight is the court. So what we've got to do, my lord, ultimately, is your lordship has to look at it and say, is it rational or is it not? In the same way as the courts have set aside, retrospectively, the ban on hot meals, as the Supreme Court of Appeal did, and exercise, and the ban on cigarettes. Why is that important? Well, as we know, my lord, cigarettes were initially banned. PATSA brings their case. They're then successful, and then the minister no longer bans cigarettes. So your lordship's judgment is highly important, and it's very important to assess what is reasonable and what isn't. So, my lord, to cut through the argument, we deal with taxis in our heads of argument at paragraph 140, at 054-64 is the page number. Your lordship will see that they concede that allowing taxis to operate is irrational, and we give the references there in our heads. But they don't give any explanation for that. They just say, well, we're allowing it. But Lord, that is because of political pressure. There's no other rational explanation for it. So they allow this to happen. Then we have a situation with gambling, my lord. There can be no difference between gambling, and we've cited articles in foreign courts where the courts say there can be no difference, and that's in particular in the American case, my lord, in the minority judgments, where they say standing next to each other at the crapshoot or at the roulette wheel is no different, they say, to standing at church, and therefore there shouldn't be this distinction. It's not rational. My Lord, we deal with gyms and we deal with restaurants. Your Lordship put a question to my learned friend, isn't it different at a restaurant? With respect, my Lord, it must be worse at a restaurant. We all know what happens at restaurants. Loud music is played and people speak loudly. What we put up in our papers, my Lord, is a study that says singing doesn't increase, because that's what the minister says, but you sing. Singing doesn't increase the transmissibility. It depends on how loud you sing and how loud you speak. So, and if you're wearing masks, that's going to be prevented anyway. So at the end of the day, when we look at the papers, and I can give your Lordship the references, we deal with this in detail with reference to facts, for which there's no proper response. But you'll see it at 001-100 to 106, in particular at paragraph 210. We deal with it at 011-113 at paragraph 244. And we set out the reasons why there's less risk in a church. Lord, we deal with it in reply at 010-5 and onwards. We deal at 010-252, religious gatherings versus supermarkets and workplaces. We deal with at 010-253 with taxis and aircraft. And we deal in our papers at 010-274. So, my Lord, we respectfully submit that there is tremendous detail where we put up facts and circumstances as to why these other activities are no more risky or less risky than meeting at religious gatherings. In fact, the opposite, and the same as what the Muslim Lawyers Association have done. And we give your Lordship details. And we reference in our heads of argument, page 46, 103, the international law experience, the foreign cases, and from pages 52 to 56, my Lord. Your Lordship will see how the judgments internationally have similarly dealt with these questions. And all of them, my Lord, all of them come to the conclusion that it's irrational to ban all the ones we've referred to. There are very few cases of which we were able to find in foreign courts where they've said an absolute ban is acceptable. France, Germany, all around the world, nobody accepts in the general world that their absolute bans are acceptable for religious gatherings. Because what that brings your Lordship to is ultimately, if there's a less restrictive means to allow people to gather as demonstrated by these other events, then you have to afford those same rights to religion. If you say people can't sing, well then fine, pass a regulation that says so. But that doesn't mean you can't gather. So, my Lord, at the end of the day, we submit that it's demonstrative that there is an irrationality. I referred your Lordship, for instance, to the situation that happened in July 21, where suddenly ministers can have meetings for purposes of emergency services, but not otherwise, again demonstrating the irrationality. And ultimately, my Lord, I referred your Lordship to the anecdotal evidence. All the minister relies on, your Lordship will find at 011-62, paragraph 88 of the papers. It is perhaps appropriate that I just briefly take your Lordship there. It's 011-62, my Lord, and we'll direct your Lordship there. Your Lordship will see that what we deal with is the only 3 anecdotal examples, it's from paragraph 88 onwards, which the minister mentions. Now, your Lordship referred, and you said there was the people coming internationally, and they were part of this spreading. Lord, that was a meeting in Bloemfontein, as we deal with at 88.1, on the 9th to the 11th of March. That was prior to any regulations. Nobody had said you can't meet. Nobody had suggested that it was safe or unsafe. International borders hadn't even been shut yet. No regulations had been promulgated. So it's not an appropriate example, my Lord, because after that regulations come in, and not one example after the regulations have come in has been put up in the papers to say there was a super spreader event at this church or that church. Which brings us to another point, my Lord. The minister herself defines a super spreader event as a mass gathering where there are no protocols in place. We deal with that in our heads. Once she accepts that, any gathering for worship is not a super spreader event because there are protocols in place, like in all the others, and there are limits. The Lord, we deal in 88.2 with the Malaysia point. That again took place 27 February to 1 March. News reports indicate this was a 4-day mass meeting hosted by an Islamic missionary movement in Kuala Lumpur, where 16,000 people were there, my Lord. That is not an example that is opposite where we're dealing with the present situation. And there's a newspaper article that they rely on. And it was only afterwards that these kind of gatherings were banned. And the third example, the anecdotal evidence, your Lordship will see, is the US choir practice, my Lord.
Mr. Botha, you should be wrapping up, eh?
I will wrap up, my Lord, shortly. I'm going to need about another 10 minutes. The point I make, I commend this to your Lord, we deal with each of these. This was before, again, there was no social distancing, a choir meeting where people sat next to each other and we give the facts. And we deal with the South Korean example, which is a red herring. And as we explained, my Lord, all of this happened before the regulations were in place, and we deal with those facts. So what are the facts before your Lordship? Those are the facts before your Lordship. And what happens is subsequent to that, the churches are opened up and before the restaurants and then subsequently shut again. My Lord, that brings us, that's for the rationality argument. I've dealt with the fact that you can meet in a restaurant or otherwise, and we submit they are flawed. Lord, briefly on the mootness argument, I've already addressed clearly, my Lord, with reference to the government gazettes, of which you may take judicial notice. Briefly on judicial notice, and I'll keep it very brief. The requirements for your Lordship to take judicial notice are two things. Your Lordship can take judicial notice of legal matters, such as government gazettes. The judgment in that regard is S versus Di Stefano, D-I-S-T-F-A-N-O, 1977-1 of the South African Law Reports, SA 770C, a decision of the Cape Provincial Division. And he, with reference to the Criminal Procedure Act, and it's similar to, and it's in line with Section 5 of the Civil Proceedings Evidence Act, which says proof of law, anything published in official publications, judicial notice shall be taken of any law or government notice or of any other matter which has been published in the Gazette. So once it's in the Gazette, my Lord, your Lordship can take notice of it. That's judicial notice as regards the law. Then, my Lord, there's judicial notice as regards facts. The requirements of that are that the facts must be notorious or so well known as being incapable of dispute among reasonably informed and educated people. They must be locally known facts, i.e. where the court sits, facts readily ascertainable from sources of indisputable accuracy, and political and constitutional matters such as the constitutional status and the history of South Africa. That was dealt with recently in a decision in the Free State, MEC, Department of Police, Roads and Transport, Free State versus Roberts, 2020, Volume 3, SA 478, decision of the FB, Free State, Bloemfontein Court, my Lord. It explains that exactly that test that I've described to your Lordship. And it goes on to say in the digital age, it has been made easier to ascertain facts, and the court may take judicial notice of such material when it's readily available and reliable, however it may come to the court's attention. Emphasis must be on the material's availability and reliability, recognizing that in our technological era, information which in the past have been unearthed only after lengthy investigation may now be readily available. So I commend that, and that, my Lord, is in line with the Supreme Court of Appeals judgment in Grootkaal Community and Others versus Botha at 2019, Volume 2, SA 128, SCA. 2019, Volume 2, SA 128, SCA. So, my Lord, they need to be notorious, they need to be readily available. The government gazettes anywhere before your Lordship, what it demonstrates is the threat hanging over people's heads. My Lord, the AfriForum judgment, which we've referred to and also uploaded, there, the distribution of the funds had already taken place. The court says, I can't set aside and review the decision, but it says, I'm going to give a declarator. Ultimately, my Lord, there were a number of cases we've referred to Pridwin, P-R-I-D-W-I-N. It's in our authorities bundle at 055-5. Your Lordship will see that in that case, that was about a private school, and it was discrimination and, again, religious matters. and it refers to Pillay, which is also, I've referred your lordship, at 055-789. In both of those matters, these are religious freedom matters. The court found it was in the interest of justice, and that's the test. Is it in the interest of justice? And that's what your lordship has got to weigh up. The test is at paragraphs 48 to 59 of Pridwin, and at paragraphs 32 and 35 in particular of the Pillay judgment. And in both instances, the court finds, due to the nature of the right, due to the circumstances, it is appropriate, even if it's moot, because there they'd left the school, they were no longer there to deal with the matter. So, my lord, especially, and that's where I argue the mootness, it's in the context of religious freedom, and in the foreign law cases, from paragraph 60 of our heads, my lord, we set out a number of foreign law cases where the courts found it's not moot, because there's this constantly moving goalposts, and because of the interests of justice, and because of the importance of religious rights and freedoms. Your lordship will see that. We summarize that, amongst others, at page 05433 onwards, and in particular at 60.2, where it says it is of grave importance, the interests of justice, and especially since they involve government's respect for and protection of fundamental human rights during a time of national disaster. Those are, amongst others, the reasons given in the foreign cases, which include the Roman Catholic Diocese case I've referred to, and Reverend Dr. William J.U. Phillip, which was a decision of a court in Scotland, my lord. So those are examples of foreign law cases where they come to the same conclusion. Lord, that brings us to section 36 and the policy issues. As far as that is concerned, my lord, policy is nothing more, and I'm going to be brief. It's dealt with in paragraph 46 onwards in the Essau judgment. Even if they contend it's a policy approach, it doesn't mean that they're not subject to oversight. It's not about, as they seem to think, that means picking winners and losers. That's not what the cases say. I commend to your lordship paragraph 44 of the AfriForum judgment as well in that regard. And ultimately, my lord, the issue here, as I've submitted earlier, is this is the vehicle the minister has chosen. She could have chosen new legislation. She could have chosen different legislation. In the absence of any parliamentary oversight, it can hardly be suggested that a policy can't be reviewed in these circumstances. They've chosen the DMA, the courts have reviewed it, they reviewed it in AfriForum, and they did so in the Essau judgment. So, my lord, the rationality analysis remains. Your lordship will see that, and that's also the same in the foreign courts. Your lordship will see that in our heads, paragraph 103, page 054-48. We deal with, in numerous cases, the excuse about these polycentric matters overseas. They've also dealt with them and said they can interfere. So insofar as the Constitution enjoins your lordship in interpreting fundamental rights, your lordship would do so. That brings me to consultation, my lord. Consultation we deal with in two places in our heads. Your lordship will see that we deal with it up front in the heads of argument, in the central arguments. We deal with paragraph 12 in particular of the relief sought, and we explain to your lordship the nature of consultation. I would draw to your lordship's attention the judgments, and your lordship asked my learned friend, what is the basis for the consultation? So, my lord, the authorities in that regard, and this is very important, it's Scalabrini, my lord. We deal with it in footnote 63. It's at page 054-21. And that was followed in the Somali judgment. They're both Supreme Court of Appeal cases. And what those judgments tell your lordship is that when you're dealing with a consultation issue, where there's a matter on which, in fact, they're also in our authorities bundle. Perhaps I should just take your lordship there briefly, my lord. I'll be 3 more minutes on this and probably 5 minutes on the other matter.
You're over speaking and you say the same. Someone thinks you just over elaborate, but yes, you must wrap up now. It's more than an hour.
Yes, my lord. If your lordship will have regard to the Scalabrini judgment, his lordship, Mr. Justice Nugent, finds that where there is It's at paragraph 69 to 72 of the judgment. Your Lordship will find it in the authority bundle. It starts at 055-874. And at paragraph 69 to 72, His Lordship, Mr. Justice Nugent, says the following. It says, nonetheless, at paragraph 68, he starts, indeed, circumstances of rational decision-making calls for interested persons to be heard. And he explains that. He then says at 69 that the process by which a decision is taken, and this was a legality case, my Lord, so you still needed consultation, and contradiction decision on the merits of the matter under consideration might itself be impeached for want of rationality. And he refers to the Democratic Alliance case. Then he says, in this case, at paragraph 70, I'm reading at 055-875. In this case, the Director General was pertinently aware that there were a number of organizations, including the Scalabrini Center, with long experience and special expertise in dealing with the asylum seekers in Cape Town. His representative, Mr. Yusuf, had specifically undertaken to consult with those organizations on any proposal to close the Cape Town office. In the absence of any explanation for not having done so, I'm left to infer that the Director General's failure to hear what they might have to say when deciding whether that office was necessary, fulfilling the purpose of the Act, was not founded on reason and was arbitrary. Even more so, to stage what was in truth the charade that could only have misled interested parties as to the intention of the authorities, which was inconsistent with responsiveness, participation, and transparency. So the test, my Lord, is that if you're dealing with an entity with specialized experience, with long experience, it's appropriate to consult with them. It's not to say that the failure to consult with any interested party will set it aside, but such duty, the learned judge summarizes in paragraph 72, will arise only in circumstances where it would be rational to take the decision without such consultation, because of the special knowledge of the person or organization to be consulted of which the decision maker is aware. The suggestion that they were not aware of us, my Lord, doesn't go up. That's blatantly untrue. We've demonstrated that we consulted on 2 occasions, but whenever they wanted to pass regulations such as these, they don't consult us. We demonstrated, my Lord, that at various times there were between 15.5 and 18.5 million constituents that were represented by freedom of religion. Fundamentally, freedom of religion is the kind of entity you would need to consult with and would want to consult with. So, my Lord, at the end of the day, we also sent letters, and I can give your Lordship the references where it's dealt with in the papers at 001-107 and on. 010-261 and on. 010-18 and on. 010-261 and on. Same 268 at para 99.1 and on. So, my Lord, at 001-81 and on. And a paragraph 166. The difference was, my Lord, we'd been writing letters. From the moment that they announced the risk-adjusted strategy, we were recognized. There was an express undertaking by the Minister's deputy that we'd be included. That's at 001-81, paragraph 158. We're no distinguishable than the Scalabrini case. There was an undertaking. We had a personal meeting with the Minister, 001-84, paragraph 166. And we were included with meetings with the President and thereafter excluded. On the 1st of September 2020, first meeting on 2 September 2020, that's 001-89, paragraph 176. And in the second meeting on the 17th of March 2021, my Lord, in the gap, we met before with the President and after with the President. That's at 010-236, paragraph 11. And it's dealt with in our heads, paragraph 66, my Lord. And also under the particular heading of dealing with the consultation approach. In those circumstances, there is no doubt, you'll find it at 054-68 of our heads, it's chapter 10. There's absolutely no doubt that there needed to be consultation, my Lord, with 4SA. If they consulted with us, they could have looked at reasonable ways of limiting the restrictions. And my Lord, that with respect is dispositive of the issue of consultation based on the authorities. The last topic, my Lord, is essential service workers. Ultimately, my Lord, they are defined in terms of Annexure D. I probably should just take your Lordship to the regulations. The regulations, Your Lordship will find at the definition of essential services is at 055-1635. 055-1635. Your Lordship's being directed to the page. There's a Gazette bundle there, my Lord. Your Lordship will see the definition of essential services. The definition means the services listed in Annex D. Lord, if you can then go to 055-1665. 055-1665. There Your Lordship will find the definition, or what is in Table D. I'm taking Your Lordship there now. I'm directing Your Lordship to the page. What Your Lordship will see is it says essential and permitted services referred to in 16.3 of the regulation shall refer to the list of essential services as set out in B below, and, see my Lord, the and, such other services are set out in Alert Level 4, and where technological, industrial, structural, or similar requirement of the service necessitates a continuous or shift operation as set out in directions as set out below. And look at B. Essential services means the services as defined in Section 213 of the Labour Relations Act. That's Your Lordship's committee that Your Lordship chaired, and designated in terms of Section 71(8) of the Labour Relations Act, and which designation remains valid of this regulation and as listed below. So they then list a specific list of services, which include medical health practitioners, outsourced administration, the insurance environment. These are matters, my Lord, that would not be covered by Your Lordship's committee, because these are private entities, not essential services such as the police, nurses, etc. There are therefore two pathways to essential services. The one pathway is through the committee that Your Lordship chaired. The other pathway is being included on Annex B. For instance, wholesale and retail stores for stocking, production and sale of goods, critical jobs for essential government services, essential municipal services, goes on, care services, social relief of distress provided to older persons, mentally ill persons with disabilities, funeral and cremation services, newspapers, my Lord, that's not under your committee. Production and sale of chemicals, that would not be under your committee. Essential gold refinery, private security services, etc., my Lord. It goes on for 2 pages. And if Your Lordship looks, even implementation of payroll systems, that wouldn't be Your Lordship's committee. These people didn't apply to Your Lordship's committee to say, this, please make me an essential service worker. So there are clearly 2 channels on a proper interpretation. It actually goes for 3 pages. It even goes over the next page. And in addition, my Lord, as we set out in our heads, where we deal with the importance of the classification, that's chapter 9 of our head 05466. And we dealt with it also at the beginning of the heads, my Lord, in that top section. We point out that the President actually promised to make us essential service workers in a letter. And in those circumstances, it must surely be irrational to refuse to allow us, and the ultra vires argument is simply unsuccessful. Lord, finally, just in regard to the relief, therefore, we submit, Your Lordship will find the amended notice of motion. There was much debate about it yesterday. Your Lordship will find it at 001-563. That is the amendment. Your Lordship will remember there was an objection. There was an objection only to paragraph 7, where we sought to expand the relief. We didn't do so in the end. There was no debate about my learned friend about supplementary affidavits, my learned friend's predecessor, Ms. Pillay. What the debate was about was that we could file our amendment because we weren't going to pursue that. Paragraph 13. What's the difference
between the relief you seek and the other parties?
My Lord, only the additional relief that we seek is the consultation. So paragraph 7, if Your Lordship goes to 011, the 563 that I've just referred Your Lordship to, and I can take Your Lordship to it very briefly. It's part B that Your Lordship needs to look at. You don't need to look at part A. I'm directing Your Lordship to the page, 001563. Your Lordship will see the first part is part A. We've already had that fight. Part B, Your Lordship will find commencing at page, I'm directing your lordship there now, 001-568. Your lordship will see declaring the regulations published on those dates invalid. So we say we're inconsistent words, retrospective and invalid. So that's the declarator. Paragraph 8, my lord, those were the subsequent regulations. We're not persisting with that, as we made clear in our heads. We explain this all, my lord, in the introduction to our heads as to what relief we're pursuing. The 9 and 10, the religious leaders, paragraph 10, my lord, is declaring the failure to include religious leaders. That is important as a specific category of essential services. That's what we seek. That's different. So the failure, what you're going to do is declare the failure to declare us essential service workers as unconstitutional and invalid. My lord, then we deal with
declare whom?
The religious workers, my lord.
Does it include all the religious workers?
No, it says religious leaders.
Yeah.
Religious leaders, my lord, which is a phrase, as your lordship would have seen from the government gazette, that the government themselves have used.
Okay.
So that was the one that they used in the 14 July government gazette, for instance, to say you can meet in front of a religious leader. So there can be no objection to that. A religious leader is clear. It's like saying a psychologist or somebody. And so we submit that paragraph 11, that it would be appropriate for your lordship under just and equitable to order them to include us as a specific category as the list of essential services. Now, my lord, paragraph 12 needs some explanation. If your lordship finds that we're correct, that there should have been consultation before the promulgation of December regulations and the January regulations, and your lordship put, and I didn't address this earlier, but your lordship put to one of my learned friends, but the minister is acting under great time constraints. With respect, as we set out with respect in our heads, dealing with the Eastern Cape situation, my lord, your lordship will see, it was Ms. Martin that you put it to. In the Eastern Cape situation, they saw the peak of the infection coming for miles. My lord, we deal with that at 054 to 24 of our heads. And then we deal with that in more detail later at paragraph 142 at 054, 65 of the heads. Your lordship will note that it was common cause what was happening. And at that stage, there was a wave, and the second wave in PE had already, because that was, your lordship will recall, the Eastern Cape was the first part to get the second wave. That was in early September. Based on the statistics, they knew where that was going, and that wave had already peaked by November 2020. They only put the regulations in December, towards the latter part of December, 29th of December, once they'd already passed the peak. So we say you had months to consult. There's no reason why you could not have consulted. And if your lordship finds with us, as we make these arguments in the heads, that if they should have and they could have consulted, then your lordship would set aside the regulations for procedural irregularity as dealt with in SL. In SL, they found that the time for consultation was too short because they were dealing with the RAS at that stage, but that was under the first wave, my lord. When we have the second wave, as your lordship sees from that diagram I referred your lordship to that comes off Google, that the minister put in a supplementary affidavit, you have months to prepare for these waves. Everybody tells us the waves are coming. They consulted with us in September and in March, but they don't consult in between. That is a self-standing ground upon which your lordship will set aside the regulations. What we're asking for under Pre 12 is an additional item of relief where we submit it is appropriate to declare that we are a party who they should consult with, but your lordship doesn't need to find that in order to set aside the regulations for the absence of consultation. So your lordship, that's the context of 12. So my lord, those are the submissions. 13 and 14, as we explained in the heads, that is to deal with the Eastern Cape scenario. We admit that we found difficulty in formulating it. That is to provide guidance where we say that they should follow the data in respect to the spread of COVID. But your lordship may find for us under paragraph 7 without granting that additional relief. That would be part of just and equitable relief. So that's the relief that's different in ours compared to the other parties, my lord. Unless there's anything else, my lord, I believe those are my submissions.
I think it was far too long. I think I should have cut you down just to over-elaborate, but yes, there's nothing further.
Thank you.